All right, everybody, it is 8 a.m. here in sunny Southwest Florida. We're going to get started this morning. I hope everyone can see my screen. We are going to be talking about listing to closing and how to get you closed. So this is actually my favorite presentation. I've done this a couple of times in the past, live, now on Zoom. And the purpose of today is to help you as a realtor think through your entire process from listing to closing so that you're up getting started on the right foot with your seller, all the way through bringing the buyer and getting you closed. We're going to talk about a lot of stuff. I laughed a little bit as I was polishing up this presentation. It's a little eclectic in terms of the slides. So I'll post them on YouTube like I always do, and I will email you the slide deck after the presentation. But so let's get started. Uh, my name is Sam Saad. I am an attorney here in Southwest Florida. And because I'm an attorney, we're going to start off our presentation today with a disclaimer that I'm providing you advice, shall not constitute legal advice. We don't have an attorney-client relationship. And if you have any specific questions, you can put them in the chat, ask them later. But if you want an attorney-client relationship, then you need privately. A little bit about me as your speaker today, of course. For those of you that have been on my presentations in the past, you know I serve on a variety of committees and boards for realtors, particularly NABOR's Legal Resources Committee and the Florida Bar, Florida Realtors Joint Contract Drafting Committee that creates the FAR Bar contract. These are my favorite things. I love working on contracts. We do a lot in our office in terms of commercial and association litigation, probate, estate planning, and asset protection. We work throughout the state of Florida, but I do have offices in Southwest Florida. And of course, I have a title company, and we will process your closings for a very low fee and excellent service. A little bit about today. We're going to talk about the title process, what we're doing to service you and your customers, how you can take a better listing, getting that contract properly signed and getting you closed. So it's a lot on the agenda today. I have a lot of slides, but as you all know, I talk pretty fast, so we'll get through it. Let's talk about the title process and what we're doing in the background. You get the contract signed, you send it to my office, and then what the heck are we doing? Well, immediately we're starting off with the title search. Right away, we order a title search. We find out what's going on with the title because what the parties have ultimately bargained for, of course, is marketable title. That is a title that the buyer can resell in the future. We order a survey wherever we need to for single family when there's a loan involved. And the survey to me is really, really important document because it's actually the second most important document in the closing because it relates the document to where the property is on the earth. And that's obviously pretty important because the address is not on the deed. We, of course, make sure the property taxes are up to date and verify that everything has been paid. We look for the utilities and the HOAs to make sure they are all current. And of course, most importantly, we prepare the title insurance commitment for lender and owner's title coverage so that if there is a problem, the buyer is covered and the lender is covered. And I'll say in 1 second about this. People say, well, who do you represent in the closing? Well, Sam Saad, the attorney, represents either the buyer or the seller. When the title company is doing the closing, of course, we represent everybody and we have a fiduciary duty to all of you to make sure that the contract is properly followed. And that's where us issuing the title commitment becomes very important. We are reviewing the loan documents, coordinating with the lender to make sure that everything is properly signed, documented, that the loan is closed. And then, of course, we conduct the closing. We go through the documents with the parties, which I think is very important. It's important to me that my clients and my title company customers know what they're signing and why. If it's an educational process, I think it helps our whole industry. And then, of course, we get to record all the documents, make sure that everything is up to snuff with the clerk of courts, and we release all any existing mortgages and things like that. So what am I doing for you? Well, specifically, managing the deadlines, helping negotiate inspections, getting the loan organized. If there are short sales, which scarily they're starting to come back in our market, and then of course doing the closing. And all the while that I'm talking to you and helping with these issues, my office is clearing the title, getting the estoppel letters, dealing with taxes, getting utilities organized, and all the other things that are going on in the closing process. So we begin the title process once the contract is executed and delivered. And don't forget, you need a signed, fully executed contract delivered to the other party, whether it's the buyer, the seller, whoever's making the final offer. And that is under contract and the process starts. So we're coordinating all the interests of everybody, the buyer, the seller, the lender, you realtors, and we make sure that all the requirements for settlement are fully satisfied. That's what that title commitment tells us. What do we need to get to have marketable title at closing? And we're always looking out for the red flags. So before I dive into all the red flags, does anybody have any questions? Because there's a lot of red flags I want to go through.
Yeah, hey Sam, it's Tom Major. You also do open permit search, correct?
Say that again.
Do you do open permit?
We do a lien search that includes permits. It includes utilities and taxes and other little items that come up on the property. But permits are obviously the big one that we get hung up on a lot, making sure that the permits are closed. I will say this about permits, Tom. They are not a title issue, and we can close with open permits. Those are on the neighbor
Right.
contract in particular, they're an inspection item. So we have to deal with those separately. But we of course deal with that in our office.
Okay, thank you.
Sure. So what are the red flags that really can hang up your closing? Well, there are a number of them. Divorces and separations, bankruptcies, foreclosures, recent marriages of the parties, judgments, deaths, and easements, all can be red flags. I'm going to talk about some of these and how to deal with them a little bit later, but things like divorce or separation, if the parties are divorcing, we'll talk about what that means. If they are fully divorced, there is no separation in Florida. Of course, if you're in bankruptcy, then you're talking to the bankruptcy trustee and you're going to want to have a conversation with them about your sale because they're going to be the ultimate sign off and you're going to need court approval of the sale. If there's a foreclosure going on, that extends your payoff timeline, dealing with the foreclosure attorney. And that's really where someone like me in my office can come in and dive in because we understand foreclosures. We do foreclosures in my office, and we can talk to them and get those payoffs and find out what the issues are that might hold up closing. Recent marriages of the seller or the buyer are always interesting because those present title questions. Is this going to be sole and separate property? Things like that. Um, Liens or judgments against the property always have to be cleared and paid off. People are confused in the contract, especially the neighbor contract, where it says a monetary lien is not a encumbrance on the title. It just has to be paid at closing. And sellers get tripped up. They don't realize if I've got a code enforcement lien over here and I'm selling a property over here, this code enforcement lien can affect this property because of the liens attached to every property owned by the judgment debtor in the county. Easements, of course, if there are easements, those have to be shown on the survey. Sophia, you're asking about trust. We're going to talk about trust and how to sign for trust. Those aren't really a red flag. Trusts are pretty easy to deal with, actually, as long as we have the trust agreement. Few more things. Known encroachments. This always creates an issue. For example, like in the Gray Oaks community here in Naples, the surveys are off a little bit, and so we get a lot of air conditioners that are in setbacks, few pool cages in the setbacks. So encroachments can be a real big issue. Sellers and buyers not present for closing. That, of course, can be a a holdup, but not necessarily a difficulty that has to be dealt. It just has to be dealt with through a remote online notary or a mobile notary going to the person. We'll talk about a little bit more about powers of attorney, trusts, and probate. But basically, if you've got a power of attorney, we need the original. So, as the realtor, we ask you, please go to your seller or buyer and get that original power of attorney. It's got to be recorded. Trusts, trust certificates can be a little cumbersome to get organized. We got to read the full trust agreement, and sellers don't like to turn those over, but you do need to provide that. And of course, your attorney, if I'm the seller's attorney, the attorney-client privilege will protect that trust agreement. Probates, foreign sellers, guardianships. We'll talk a little more about these. Association liens, those can be difficult. You may need to bond them off. The seller may need an escrow for their portion. It just depends on the situation. But association liens, we got to be looking out for those. And I will say this about associations, I'm say it again later. Make sure you know the communities in which you are selling. If there are roof issues on the condominium, if there's a whole landscape redo or a paint job that's going to be redone, it's going to be special assessments. You need to know about those because those become liens if they're not paid. So one of the things that you get includes in my office includes looking for issues that will delay the closing. But I think what really makes us special, of course, is we are going to be working to resolve them to keep the closing going. I always say we can solve any problem related to real estate. We will get this property sold. It may just take a little bit of time. And that is really the issue. With time, all real estate problems can be solved. Does anybody have any questions about the red flags? Okay, let's talk about taking a listing and what can you do when when you go to take a listing to make the process more smoothly. And there's a few pointers that I'll point out. Oh, Deborah, you have a quick question about HOA? They do not have to agree to the escrow, Deborah, so no. Um, so taking a listing, before you go on the listing appointment, look at the prior deed. There may be a link in the MLS or on the property appraiser's website, but the deed tells you who you need to deal with. And if there are many people on the deed, if it's an LLC, we're talking about how to deal with all this, you've got to look at that public record and make sure that you see who's going to be on your title. Are there past due taxes? What does the clerk of courts have to say about deceased parties or ex-spouses? Is there an LLC owner? Is there a trust that is the owner? Did somebody sign as power of attorney? I'm going to go into detail on all of these. One thing I do want to pause and talk about now, of course, is the fraudulent seller. Please be mindful on vacant lots, foreign sellers who don't want to be on FaceTime, who just do things by email. It's very important in this day and age of the internet with AI and scalable fraud. I hope everyone knows what scalable fraud is. That's fraud on a mass scale where one fraudster defrauds many people at once. That's happening now. It's very scary. Just be very mindful of who you're dealing with when you're selling a property. The other thing is when you go on a listing appointment, I think it makes you look really professional if you pre-fill and pre-deliver listing documents and disclosures, because that shows that you've done your research and you know who you're dealing with and what the property will look like. And one thing I'll say is if you ever have a question, even if you are just getting ready to take a listing, give me a call. We'll talk about what the property, we'll go through the public record, we'll get you a net sheet that you can show your seller. A lot of things that we can do to help you get that listing. But talking about fraudulent sellers, what are we looking for? Because this is such a big deal right now in our market. Vacant land, no mortgage, foreign owner or an absentee owner. The seller's not willing to talk on the phone. They want everything by email. Misspelled words and bad formatting in emails, although this has gotten much harder to detect with AI, these cut and paste looking emails and the misspellings. The fraudsters are getting much better with their English. Uh, so be very careful about that. And one tool that's not on my slide that someone mentioned in the comments, use forewarn. Check those phone numbers and those names. How do you prevent fraud? Number one thing, get them on a Zoom call, meet them in person, and check that ID. And then the last thing I'll say about fraud is Google everything. Sellers' names, email addresses, phone numbers, just see what comes up. Maybe somebody posted that phone number on a website where they talk about fraud all the time. So be very, very careful about that. And just stay alert. Please stay alert. You know, when you're on the listing appointment, ask your seller for a few things that are going to make your process go easier. And if they don't have them, that's an indication of more work that's going to have to be done later. Ask for their prior title policy because this solves a lot of title issues that can delay closing. If somebody wrote over an easement or an encroachment, um, and it's on the prior policy, that will solve your issue of having to deal with that again. Um, Kimberly, that's a good point. If somebody does not argue about a commission, they don't negotiate their commission, they're just happy to pay it, that's an indication of fraud. Prior surveys, ask them if they've got a survey. If it's certified to the seller and less than 10 years old, that saves a few $100s because then you've got a prior survey that we can just do an affidavit for. Ask your seller for their mortgage statements and ask them, do they have a second mortgage or a line of credit? Ask them for association information, a statement from the association about who they pay, because that's going to matter for getting estoppel letters. And then know the association that you're selling in, because if there's a master and a local, you're going to need both sets of both sets of disclosures and paperwork. So get the association documents because their buyer has the right of rescission. And actually, I need to update this slide. It's no longer 3 days. How many days is it? Somebody, how many days is
7.
it? What, Jessica?
7. 7.
7 business days. You are exactly correct. 7 business days now. So be very cautious about that. The association documents is now a much bigger deal. And then don't forget to ask for leases and powers of attorney, death certificates, trust agreements, and LLC operating agreements if they're on title. Once you get the listing, now we got to talk about how to deal with all this paperwork. If the buyer takes the property subject to any leases that are in place before closing. So, the tenants have a right to their leasehold estate. So the seller can't sell out from under a tenant without getting the tenant's buy-in. So make sure you check the box for lease occupancy provisions on the contract, because if you don't check the box, then your seller is going to be buying out those tenants, and that gets really expensive. One more point about leases here. Airbnb and VRBO, they don't transfer accounts. They have limited opportunities to transfer pictures and reviews, but you need to cancel the leases. Otherwise, you're going to have a problem getting the tenants to move to the new buyers under their accounts. And you need to maintain the property until the property manager, as a property manager, until the leases are terminated.
Hey,
And if
Sam.
you have a property manager, hopefully they can
Sam,
help transfer.
Sam, can you hear me?
Question?
Yeah, it's Guy.
Hey, guy.
On the leases, who do you guys assist in that, or is that up to the realtors to coordinate with the buyer and seller?
We typically will do it because we have to. If you look at the last bullet, I didn't get a chance to say it yet, but we deal with the leases because we need affidavits and estoppels. So we will help everybody understand what their process is. The one thing that we don't do in part of the titling process is notify the tenants. that who the new payer, the new payee is going to be. So the buyer needs to send the tenant a letter and say, "Hey, I'm your new landlord. You have to pay me now."
And
So
that,
that
and
becomes an issue.
typically when I do those, I ask the seller to notify and copy the buyer and try to do some kind of handoff.
Yes, a handoff is
Yeah,
usually coordinated, and we can help with that process. Katie or I in my office can help with that process, but the it typically falls on the buyer to make sure they're getting the rents.
thank you.
Yep. Okay. Any more questions about what we've gone over so far? Because we're going to dig into who signs for who next, and that gets a little complicated.
I have a
Jessica?
question. When we ask for the trust LLC, because we find on public record that the deed is under a trust and deed, I'm sorry,
Yep.
that the deed is under a trust or an LLC, I mean, we should ask the seller for the actual operations agreement for the LLC and the
Operating
actual,
agreement for the LLC. I'll go over that in a few minutes, but yes. Yeah, I'll go. It's one of my slides coming up here in a minute. But yes, you will
okay,
need
okay,
that operating agreement because that is the Bible of the LLC in terms of who signs for the LLC. So we need to get
okay.
that document if it exists. So let's talk about who signs for who. When you've got a limited liability company seller, as Jessica was just asking about, there are two documents that control LLC operations. There's the Articles of Organization, which is like the declaration of independence of the LLC as a separate entity. It's going to be in the public record. You can go to Sunbiz if it's a Florida LLC and find it there. Then you're going to get the operating agreement, which is not public. You have to ask the members for um, a copy of the operating agreement. And that is a very important document because it's like the constitution of the LLC. It tells us who's in charge, how it operates, who signs, and who gets the money, which are very important in the closing process. And there are two kinds of LLCs in Florida. There are manager managed and member managed LLCs. In a manager managed LLC, you want your manager of the LLC to sign your listing agreement, sign your contract, and sign your deed. In a member managed LLC, the member or members sign for the LLC, and you may have several of them, and they all are going to need to sign um, your listing, your contract, and your deed. The one thing we're looking for who has the power to bind the LLC. And one other point about LLCs in Florida, there's no such thing as a managing member anymore. So if you see a managing member on the LLC, then have now been put on notice that it's a member managed LLC and the members need to sign for it. And that can be very annoying to managing members who thought they were in charge, but the LLC laws changed back in 2014, and people have not updated their documents. If there's no operating agreement, then we look to the articles. If it's unclear in the articles, everybody signs for the LLC that's involved, all the members. And one other point about LLCs, you do not have to register the LLC to transact business in Florida, except, and I should put this on the slide for next time, except if there are short-term rentals, then the LLC will have to be registered to collect the sales and TDC taxes. Questions about LLCs? Okay. Let's talk about trusts. When you have a trustee seller, you have a few additional things that you have to think about. First of all, trusts do not hold title to real property in Florida. Trustees hold title to real property in Florida for the benefit of the beneficiaries of the trust. And again, we're looking for who has the power to sign for the trust. And it may be a successor trustee, there may be co-trustees. You need to examine the trust agreement, particularly the powers of the trustee section, to determine who has the authority to sign for the trust. Now, if the trust powers are in the deed from the seller, That is the magic language of authority to protect, conserve, sell, lease, encumber, otherwise manage and dispose of the real property. And the seller trustee is the trustee that is on the deed. So there's no successor trustees involved. Then we do not need the trust agreement. We just need the current trustee, the original grantor, to sign the deed, and all is well. So that's a little tip there. When you see the prior deed, when you're doing your research for your listing, if you see the magic words from chapter 689.073, which are listed here on the slide, in your deed, that's an indication to you that the deed says Sam J. Saad III, trustee of the Sam Saad Trust, and you're talking to Sam Saad and the magic words are in the deed, you do not need the trust agreement. And if someone asks for that, you can say, wait a minute, the powers are in the deed. That's just a little tip for dealing with title companies that don't know what they're talking about. Questions about trusts? Okay. Let's talk about divorcing and divorced parties. If the parties are divorced, then you will need to examine the marital settlement agreement, and you need to look at the final judgment of divorce. If the property was not properly conveyed by the judge in the divorce judgment, and the marital settlement agreement does not contain, or I should say the magic words are not in the marital settlement agreement either, which is convey, sell, grant to one of the parties, then you need to do an affidavit, and you may need a quitclaim deed from one spouse to the other. And they could have been divorced 30 years. If they didn't comply with the marital settlement agreement 30 years ago, too bad. We got to find the spouse and they got to sign. If the parties are divorcing, that is, they are still married, then they are married. Florida does not recognize separations. And if it's marital property or if it's homestead property, you're going to have to get the uncooperative spouse to sign. So in Florida, you are either married or not married, basically. Everybody understand that? If you've got divorcing parties, both parties are going to sign. And oh, Craig, you're asking about what if one of the parties is dead? That's a great question. What do you do when dead people are on title? You may need a probate. You may just need the death certificate of the deceased party, depending on how title is held. If it's joint tenancy or tenancy by the entireties, then a death certificate will typically operate to transfer title to the living party, and you are probably okay. You may just need a continuous marriage affidavit or a few other things. It just depends on how title was held. But if a person on title has died and they do not have a joint tenancy, you need a probate. You can't get the listing agreement signed, and you don't until you get a personal representative assigned by the probate court.
Okay,
Now,
so if we get really ugly here, what if the deceased had a will with their children? I mean,
you need a probate. You have to probate that will.
Okay.
Yeah, that's a probate for sure. If you've got a deceased person on title and it's not a joint tenancy, you're going to probate.
You're going to
Will
probate.
or no will.
Okay.
The will, people think that because you have a will, you avoid probate. No, the probate court is specifically designed to read and interpret the will and transfer the assets according to its terms. So wills are very important and useful for transferring title, but they are not a probate avoidance device. That's what trusts and joint tenancies are for. Other questions about dead people?
Just to add that when there isn't a will, or when there is a will, regardless, you still have to go to probate, and then that's
Both cases you're going to probate. One is called one is for now I can't say the word out loud. Intestate death is no will, or testate death is with a will.
Mhm.
So if you are intestate and you do not have a will, you have to go to probate and you follow the probate statutes. There's a waterfall. Who gets what, starting with the spouse, ending with the state. Katya is asking, what if the surviving spouse remarries? You may create a new homestead issue, Katya, and that has to be dealt with. John is asking how long probate can add to the timeline. Can be anywhere from 4 to 6 months to a year, depending if it's fought, if it's a contested probate. The one thing about trusts and dead people, you cannot disinherit a spouse in Florida. The Aronson cases are bad for trusts. So if you've got a trust and a dead person, you still need to talk to the heirs. So remember that. Kathleen, a ladybird deed is a great tool for avoiding probate. If you've got a ladybird deed, you file the death certificate of the life tenant, and the remainder persons get the property in fee simple. It's a great. I love ladybird deeds. They're so easy. Everyone who wants to avoid probate and doesn't have like a trust because of other problems should use a ladybird deed. I actually don't like trusts. So what if you have a power of attorney? Well, you need to comply with Florida law, of course, which changed in October of 2011. You need the formalities of a deed on a power of attorney. That's 2 witnesses and a notary. If it's a power of attorney from a different state and it's valid in that state, we can go to an attorney in that state, get a letter from them that the power of attorney is valid currently and valid under the laws of that state, and we can usually move forward with an affidavit and filing the power of attorney and the letter with the clerk of courts. If you have a durable power of attorney, it survives incapacity. That is, when the grantor of the power of attorney, becomes incapacitated on a durable power of attorney, which it has to state in the power of attorney that it is in fact durable under the statute, then the attorney can continue to act for the ward until death. Upon the death of the grantor of the power of attorney, you lose the power of attorney. The principal no longer grants the power upon death. We must have the original power of attorney for closings. If we don't have the original, we're pretty much stuck because the clerk only records original documents. So it will be returned. That's an important point. You will get the original back, but we must record the original with the clerk of courts. The only thing I'll say, if you've got a one spouse in, say, New York, and your seller is here in Florida, and they don't have a power of attorney, and they say, well, I'll just have my spouse sign a power of attorney, it's got to be signed with the formalities of a deed. So why do we just have them sign the closing documents? They got to go to a notary. They got to have 2 witnesses anyways. So we typically will not use a power of attorney when it's not already in existence, because mail-aways are just as easy. Questions about who signs for who? Anybody?
Sam, when
Yes,
someone signs a deed with a power of attorney, will I know that when I look up the deed on property appraisal website?
You will know that when you look at the deed, because if I give power of attorney to you, for example, it will say Sam Saad by his attorney, in fact, Jessica Cabal, grantor, for example.
So it will say that in the language at the top when it's
It
talking
should
about
say it in the deed, yes. And it will certainly say it on the signature line if someone else has signed for the grantor. So if you look at the deed and say I was selling my property and I had given you a power of attorney to do it for me, on the signature line it should say Sam J. Saad III by his attorney, in fact, Jessica Cabal. Or Jessica Cabal, attorney, in fact, for Sam J. Saad III. Either of them are acceptable.
On the signature line for sure, but I usually don't scroll down all the way to the bottom. I just look at the top.
Start scrolling.
Oh,
You got to look at the whole. You got to look at your public record. It's really important to look at that public record and understand who you're dealing with, because there could be a power of attorney. If there's a power of attorney, that typically means there are children or a ward and a principal involved. You got to know what's going on in there.
Okay.
All right, let's
Thank
talk
you.
about contract to closing, what you can do to make the closing go more smoothly. First of all, when the contract is signed, deadlines, 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 the clock is ticking. I've had a number of cases recently where the listing agent said, "Oh, I'll get it to you next week. We're still in the inspection period." Well, that's a problem. You have obligations to, under the contract, the buyer's got to get the deposit in. You've got to start clearing title. Documents have to be reviewed. We have to make sure everything looks good. So get that closing package to me right away with all the pages of the contract. For you older realtors out there, when the contract had signatures on page 3 and used to send the 3 pages, that never worked in the first place. So make sure you send all the pages of the contract, that original power of attorney, the original death certificate, a copy of the trust agreement, a copy of the LLC operating agreement, whatever you've got for your title. Contact information for the parties is super important. We use a portal system now through Qualia for security. I know some people don't like that, but man, is it so much more secure in the world of fraud that we live in than email. Get that prior policy, the survey, those mortgage statements, association information, commission information, leases. Get all that to the closing agent. You know, again, the association information, we need the name of the association, the contact person, the phone number, the email address for the association. Very important. The other thing is, all the contracts now say that the seller has to provide the association application to the buyer. So don't wait. Again, get that process moving with your seller. Just because the buyer's doing inspections doesn't mean that the seller doesn't have work to do. That power of attorney, those death certificates, all this stuff, we got to have the original. And we may have to order it if it's an out-of-state death certificate. On that trust agreement, we need all the pages. We need the whole trust agreement. We don't need the entire book, the 500 pages with the will and the HIPAA authorizations and the powers of attorney and all that stuff. We just need the trust agreement, which is usually 20, 30, maybe 50 pages out of that agreement, out of that book. Commission information, we need verification forms signed by your broker. Any credits and same day form, all that's got to be submitted. So you can use these 2 slides. I'm going to email these to you guys as your checklist for what you got to put in your package. And then just a final thought, you know, your closing agent is a resource for you. Give me a call anytime. Questions when you're working through your listing and your closing, even if I'm not on the deal. I'm happy to help you. I do it for free, but we will help you navigate the red flags. You know, when we're doing the closing, we really need information as early and as often as possible. If you tell me about your deal early enough, I will get it closed. We may need an extension, but we will get it closed. And just kind of like thought, what do you want from your closing agent? What do you get from my office? Accuracy and timeliness. You know, if you're ask your agent, your title agent, if you're not using my office, when they order the title commitment. If they don't say it's in their first step of getting the file open, they're doing it wrong, and you're being disserviced, because that title commitment is the Bible. And we will provide you regular information and early notification of any issues, because we know that with time we will get them solved. And with that, I will take all your questions. Somebody must have a question. Come on.
I have too many questions,
Go
Sam.
ahead, Jessica. I know you have a question.
So let's say that I see on the deed that there's an LLC or a trust, and then I ask them for the operation agreement, I think is what it's called, and then the trust agreement. Everyone, how do I know who exactly needs to sign on the trust? All the
You have
trustees?
to look. If you are not dealing with the person on the deed, so let's just take an example, because this is very important. People make this mistake all the time. If your deed says Sam J. Saad III, trustee of the Sam J. Saad III trust, and Sam J. Saad III is dead, we need the entire trust agreement, because we have to figure out who the successor trustee is and who has the power to sign as successor trustee and what those powers are. If I'm alive, then we probably don't need the whole trust agreement. We just need a trust certificate information, which is that the trust is valid, who can sign. If the trust powers are in the deed with my name as trustee and I'm still alive, then you don't need anything but the deed. See the 3 levels there? I'm dead, you need the trust agreement. I'm alive, but not signing perhaps for a variety of reasons, you need the power section. The power, I'm alive and the powers are in the trust agreement, then you're good with just the deed.
So
Mike, you had a question? Did you have a question, Mike? Oh,
I was just letting Jessica finish. I didn't know if she.
okay.
oh, go
Sorry,
ahead.
Jessica, are you good?
Yeah, I'm good.
Sam, one of the things that a lot of customers have questions on is the issue between using a title company and an attorney.
Sure.
And oftentimes, we end up having, giving that explanation. Could you just go over that quickly for everyone in terms of
Sure.
here's the differences in service between the two?
Well, and I'll use my office as the example because I have Paradise Coast Title and Escrow and the law office of Sam Saad. When Paradise Coast Title is doing the closing, you're dealing with the closer. And I'm typically not involved in every aspect of the closing, but I'm overseeing the process. When the law firm is doing the closing, I am involved in the process. Now I have standard documents that I have reviewed and prepared and for all of mine, but if you ever, even if I am doing the closing as a title company, if there's a question, I'm going to get involved to make sure it's done right. But if you're from like New York or the Northeast or New Jersey and you're used to like having an attorney and lawyering up for a transaction, you want the comfort of an attorney, even though it's not required in Florida. And I get involved and I do the closing. If you're from the Midwest, like I'm from Omaha, we think attorneys are expensive and we would never go to one. So we just use the title company. The reality is you're going to get in my office the same service, the same level of review, regardless of whether you put Paradise Coast or Law Office of Sam Saad on the contract. You're going to get me involved in the closing. And there's not a huge difference. In other offices where maybe they don't have an attorney, you're not going to be able to get amendments drafted. You're not going to be able to ask questions. Technically, those title companies are supposed to have an attorney draft specific affidavits. They're not provided by the underwriter, even though we know that doesn't happen. So I think an attorney-owned title company or law firm is the way to go for a closing because you get that level of review that you can't get at a title company. So that's not attorney-owned. Does that answer your question?
Yes, thank you.
You got it. Other questions?
Sam, it's Tina.
Hey, Tina.
How are you? Question about if there are delays on closing. How long is title commitment and or estoppel good for?
Title commitments are good through closing. There's not really a time limit on them. We do updates. We do 3 title searches in each closing. I don't think people realize that. We search the original closing when we get the contract. We do a gap search just prior to closing, and we do a gap search just after the deed is recorded. So the title search is good through that whole process until we issue the final policy. Estoppels are good for 30 days by statute. So you will wait until you're within 30 days of closing to order an estoppel.
So if you had a case and we had a estoppel done, but the people bail out because of medical issue, and now we have a new buyer closing in June, delay closing, that estoppel that we have is no longer good.
Correct. We would need an update to the estoppel, and the estoppel companies charge a fee for that.
Yeah. So who will order that and who will
We
be
would order it as part of the closing.
Okay. All right.
Yep.
Okay, our case is gonna need that because it's already 3 months old.
Yep, we'll get it.
Okay. Thank you.
You got it. Susan, you're saying is it better to have a buyer's commission within the contract or on an addendum? If I'm preparing a contract and the commission needs to be on the contract, I'm going to use one of the appropriate addendums provided by NABOR or FARBAR. I would not, as a realtor, want to trust myself to write in language about the commission or anything else, because it's unlicensed practice of law, and if you make a mistake, you may not even be covered by your E&O. So just use the pre-printed addendums for compensation. It's so easy, and they're pretty good. If you ever have a question about compensation, even if I'm not working on the transaction, give me a call. Karen, you're asking, what is the realtor responsible for when receiving and reviewing the title commitment? Karen, I say, as your responsibility is to tell your buyer or seller to look at the commitment and call the title company or the lawyer. I would not, as a realtor, interpret the title commitment, even if you feel really comfortable. It's just there's a lot on there and there's a lot of permutations to go through. Marlene, do we have a list of clauses? I keep a list of clauses, Marlene, but I don't publish them because they're specific to each situation, but I just have some basic ideas. Other questions?
On that list that you'd had once the contract is signed, I didn't see you ask for the elevation certificate.
Oh, you're right. I should add that survey usually comes with an elevation certificate, Jessica. That's a good point. Yeah. You want to get the EC if you've got it. Yes.
So I have a list of documents I usually ask the listing agent or seller. Most of them are on that. Another thing is that I'll ask for the utilities and the service providers. And I'm learning that a lot of the time, sometimes titles companies actually are in charge of the transfer of like water.
That's right. We transfer utilities. And we pull the lien search, so we get the utility information on the lien search.
Okay.
We'll get outstanding balances and things like that on the lien search.
And so then for title, I usually want to give them the prior title policy, prior survey, or prior elevation certificate. Do you guys need the wind mitigation 4-point report, home insurance policy, or flood policy?
We need the flood policy if we're going to assign it at closing.
If it's going to be transferred?
Transfer to closing. Really, you should provide all that to us because, like, if I'm the attorney on the deal, I'm going to get asked about inspections and I'll need the 4.2. Just send all that with your package.
Okay.
Okay. Jessica, you answered a question. Karen, did you have a question? Oh, she just unmuted. Okay. Other questions? All right, we are a few minutes over my deadline of 30 minutes. So thank you all very much for your time today. I'll have the slides out to you and the recording soon. So thank you all very much. Talk to you soon.
Thank you, Sam.